right, hey everybody, let's talk about Supreme Court cases. They're more fun than a barrel of monkeys. Yeah, I just said that. All right, so anyway, obviously in class we've talked about Supreme Court cases. We've talked a lot about how you might see them on multiple choice. And if you're not sure about where you might see them or how to study them or things for multiple choice, I made a Quizlet that will help out with that. Ah, yes, right here. All you have to do is go to Quizlet.com and Mrs. Clemens, and what you're going to find there is 24 different Supreme Court cases that are great to study for the Regents. So now the way, if you look at the screen right there, you see Marbury versus Madison, and then you see the definition right underneath. You can actually put it so that it's only one side, so that's like a true flashcard. So you click where that little circle was. See, look, circle, circle, and click that so that's not showing both sides at the same time. You can scroll down. You can look at all the definitions all at once. There's a game section, and let me just tell you, the games are kind of weird. I'm not sure if I like them that much, but you can play the games if you want to. You can actually message me if you'd like to, so that's kind of cool. Alright, so let's talk about some of these super-de-duper Supreme Court cases. So, first thing, we're going to categorize them, and we're going to talk about Supreme Court cases that deal with separation of powers, specifically separation of powers between the different branches. Oh my god, please tell me you know the different branches. We've got executive, the president, legislative, Congress, and judicial, the courts. Okay, so Marbury versus Madison. Marbury versus Madison is the case that if you wanted to forget it, okay, don't do it, don't forget it, because you have to know it, you have to. You can say, oh, it's a stupid name, I don't care, need to know it, have to know it, gotta know it. You will die if you don't know it. So anyway, it's one of our John Marshall cases, and Marbury versus Madison, it said that the Judiciary Act of 1789 is unconstitutional. The big thing you have to know is that it established the principle of judicial review. What is our good friend judicial review? It's the ability of the Supreme Court to decide whether or not a law is constitutional. So that's our first one. So obviously we've got a law being unconstitutional, so law, that would be the, what? Yes, the legislative branch. And then unconstitutional, it's the, yes, the judiciary. Good job, guys. All right. The next two are from the New Deal. Now listen, if you don't know these, it'll be okay. Sometimes you see them on the multiple choice together, but they are examples of separation of powers. You've got Schechter-Poultry, which said that Nero was unconstitutional, gave too much power to the president, executive, Supreme Court, judicial. And U.S. v. Butler, which ruled that the AAA was unconstitutional. It was a violation of the 10th Amendment, which gives us reserved powers. Honestly, don't worry about them as much as worry about Marbury. And then, a really good one to talk about is the U.S. versus Nixon. And this is the Watergate case that basically, remember, our good friend Richard Nixon, he had all those tapes. He wasn't a crook. He loved his dog checkers, all those wonderful things. Anyway, and so he had the tapes. He didn't want to release the tapes. He said he had executive privilege. And the Supreme Court said, dude, you're not above the law. All right, so what I did here was I found an actual Regents essay task that deals with this. So the task for this particular one was describe how the system of checks and balances functions. So obviously you would have a part in the beginning where you're like, oh yeah, well the purpose of the checks and balances is to make sure one branch doesn't become more powerful than the other branches. You might want to just live on the edge and be like, oh, the idea came from Montesquieu. Depends on how on the edge you want to be. Then it says, show how the system has been applied in specific circumstances. So you're on your own. We've already reviewed the Constitution, and you can do the legislative and executive yourself. But judicial, you would define, you would not only just mention judicial review, because I would be mad if you just stopped there. You would actually define it. It's the ability of the Supreme Court to decide whether a law is constitutional. And then we've got the two cases that I said were the best to use, Marbury versus Madison. And I put some of the specifics here. It's a ruling by John Marshall, because we care about John Marshall, which established the principle of judicial review by finding the Judiciary Act of 1789 unconstitutional, so that's judicial review, and it set a precedent, we're using the fancy words, a precedent for future rulings and became a way for the Constitution to adapt to changing times. Oh my God, you sound so smart. All right, and our other example is U.S. versus Nixon. Now listen, you could do either one of them. I put both because I'm a nerd. But the U.S. versus Nixon, President Nixon believed that he had the power of executive privilege and that prevented him from having to turn over his private tapes. The court said, no, you don't have that power. And he had to turn over his private tapes. What happened to him in the end? Was he impeached? If you say he was, I'll be mad. No, he resigned. Alright, so these are some better cases. Federalism, it's the division of power between the state and national government. Division of power between state and national government. You have to know it. Have to. Review the Constitution if you don't know it. Alright, so we have a bunch of cases here. We've got basically the best one to use, I would say, is McCulloch versus Maryland. This is the case that says, yeah, the Bank of the United States is constitutional, the elastic clause is allowed to be used, and it said that the national government was supreme. We have Gibbons versus Ogden. That said that the national government has the power to regulate interstate commerce. That's the case that deals with the ferry boats going between New York and New Jersey. All right, my super fave. Worcester versus Georgia. You really never ever see it in the multiple choice. I love it for essays, oh my God, because it can be used not only for federalism, but it can also be used for, if you're doing civil rights, dealing with Native Americans. It ruled that Georgia couldn't remove the Cherokee, so state, Georgia, because of federal supremacy, as we know, though, our good friend Andrew Jackson did not support that and helped Georgia to launch those guys on the Trail of Tears. Munn versus Illinois, it said that the states can regulate intrastate trade, trade within the state. And basically this was a case where the national government was trying to regulate trade within the state, and it said, no, you can't. That's the states. The states get to regulate intrastate trade. Wabash is basically the opposite of that. This is Wabash, St. Louis, and Pacific Railway. That's the full name for people that love full names of cases. So anyway, this one said that the states can't regulate interstate commerce because they can only regulate intrastate commerce. It's the national government that has to regulate interstate commerce. And so this led to the creation of the Interstate Commerce Commission. And what had happened here was Illinois was trying to regulate the railroads. So basically here you have the national government trying to regulate the railroads within the state. They can't do that. You have the state government trying to regulate railroads that go outside of the state. They can't do that. And then you have two other opposite cases. You've got Munn versus, I'm making up new cases. Muller versus Oregon, which says that states do have the power to limit working hours in the case of medical need, because women, they're so weak, they need to go home and cook and clean. And Lochner versus New York, it said states can't limit the working hours for bakers who are men. Honestly, the two that I would focus on is McCulloch and Worcester. Alright, so this is one that I kind of made up on my own, so it's not as super fancy and super schmancy as the Regents. But I figure that if they were to give one like this, they would first say, alright, we'll talk about what federalism is, division of power between state and national government. They did that so that, it wouldn't be, one part would be too strong. Very similar to checks and balances, only, between the state and national government. And then give two examples of how this system has been applied in specific circumstances, and give the impact, because that's what they like to do. So like I said, this one's not from a real Regents, but you know what? It sure as heck sounds a lot like one. So we've got McCulloch versus Maryland, and so we want to give the historical circumstances. You want to give as much detail as you can. So Hamilton, our good friend, he created the National Bank. He was trying to help out the country because we were in horrible debt following the Articles of Confederation. He said, yeah, I can create this bank because of this super fancy schmancy thing called the elastic clause, also known as implied powers, also known as the necessary and proper clause. And our good friend Thomas Jefferson, he opposed it. Remember, he believed in strict interpretation. Now, I didn't write all that there. You, though, you are going to write that in your essay. You're going to like it. So now this case comes because the second bank of the United States, basically, they had reapproved the bank. That Maryland, basically, they wanted to get rid of the bank. And the way that they were going to do that was to tax it. And so they were hoping that that would make it so it wouldn't be able to function anymore. So the impact of this case is that the bank is constitutional because of our good friend the Elastic Clause, aka implied powers, aka necessary and proper clause. That states can't tax the bank. And it works the same way, like Beacon can't tax the post office. It's a federal thing, like the city of Beacon can't do that. And it also set a precedent or an example for the future for the supremacy of the national government. And then Worcester versus Georgia, which I just talked to you about, it said that the Cherokee had signed a treaty with the U.S. government, allowing them to have a reservation. And this was an actual agreement. It's like a treaty, just like how we have treaties with other countries, just like we learned about with the Treaty of Versailles. That's a real thing. It's a real agreement. That wasn't something where, New York State said, hey, we're going to do a treaty with someone. No, it's the Cherokee as an independent nation and the United States government. Well, Georgia, they wanted to remove the Cherokee from the state. Well, what we have in this case is actually one of those rare good rulings. You know why? John Marshall, love you. And it said that treaties are the supreme law of the land, okay? They can only be done by the national government. It's a delegated power, okay? The president can make the treaty, the Senate ratifies the treaty. So that's all national government. But the reason why this is such a great case in my mind is because you have what happens when the president, who's supposed to enforce the laws, doesn't do what they're supposed to do. You could actually use this case for checks and balances. So yeah, President Jackson, he didn't support the decision, and Native Americans were forced on the Trail of Tears. Alrighty, folks. Well, this is the end for this screencast. Stay tuned next time for more Supreme Court madness.